Just a couple of announcements. There have been some new cases that have been posted on the website. If you haven't been to the website, please check it out. I understand it was down for a period over the weekend, but that issue's been resolved. So go ahead and check that out. There's some interesting cases, a couple out of the 11th Circuit that have come down in bankruptcy. We sent some emails out. Brian's done some write-ups, so thank you very much, Brian, on summarizing those cases. Today we have a speaker from Henderson Franklin. Some may know her, Traci McKee. She's from the Torts and Insurance Practice Division, and she's going to talk to us about a topic that's near and dear to all of our hearts, and that's avoiding legal malpractice claims. So without further ado, let's get into this.
All right, thank you. I didn't realize it was such a large group. I thought it was going to be fairly small, but as David said, my name is Traci McKee. I work for Henderson Franklin. I work in our torts division, but in our torts division, my area of specialty is focused, probably about 70% of my caseload is in defending legal malpractice claims as well as grievance disputes, and really all issues dealing with lawyers, whether it be some fee arbitrations to the Florida Bar, defending grievance matters, all kinds of stuff. So we do that. A lot of them we get in through insurance carriers, and I hope everyone out here has liability insurance. You'd be surprised how many people don't. If you don't, you should seriously consider getting it. But I have some cases that I defend, like I said, through the insurance carrier, but I also have cases where I defend individuals who either don't have malpractice insurance, or for some reason the malpractice insurance doesn't cover the claim being made. So hopefully I can give you, if you can leave today maybe with one or two pointers as to maybe some things to help you avoid having a legal malpractice claim against you or a grievance dispute. Hopefully I can help you all in that area. Like I said, maybe if you can just take one little thing from today. If anyone has a question, feel free to stop. I'm trying to make this pretty informal, so if you have a question or if you have a comment, please feel free to speak up. I won't be the least bit offended if you feel like chiming in, so it won't be just me talking. Okay, I'm going to start out today's presentation to give you just a little bit of some statistics. And when I was updating this PowerPoint yesterday, it's actually the first presentation that I've given since we got these new statistics from the American Bar Association. The ABA's Standing Committee on Lawyers' Professional Liability every few years basically does a survey. What they do is they enlist almost all of the major legal malpractice insurance carriers who basically look at the claims that they've gotten over the past two years. And what they do from that is that they basically categorize them and answer questions based upon all the claims that they're getting. They get this, I'm sure most of you that have insurance, it's probably one of your insurance carriers. If most of you are familiar with a company called Flemic, which is Florida Lawyers Mutual, which is a big carrier in Florida, they are one of the insurance companies that contributes to this survey. But what the survey does give is just gives you a general understanding as to whether maybe you or your practice area falls in the category of lawyers who have a high number of claims filed against them. So it's kind of interesting to see the statistics. So we're going to start with just some stats. The first one, it breaks it down by size of a law firm. If you look at these numbers, if you're a sole practitioner, 1 out of every 3 legal malpractice claims that is filed or that is brought is against an attorney who is a sole practitioner. That's a very high number. If you look 2 to 5 attorneys, if you combine one in the top 2, you're looking at 2 out of every 3 claims that are filed that are legal-oriented, legal malpractice, are against firms or attorneys where there is 5 or less attorneys practicing there. As you can see, the number, as there's more attorneys, the number tends to go down. I guess the firms that have between 40 and 99 are in the best percentage. Now, the basis behind this, I don't know. I think we all can speculate maybe what the basis would be, but it's certainly, if you fall within the category of having 5 or less attorneys, you fall in a quote-unquote high-risk category, I guess, is what we would consider high risk for having a claim against you. This is just a little pie chart. I know it's probably hard to see for some of you in the back. But again, like I said, 2/3 of all malpractice claims are filed against firms that have 5 or less. So that's the lion's share of the claims are being filed against those size firms. The next interesting specific, and I highlighted collection and bankruptcy. Here is the area of law, the claims filed by area of law. And I'll tell you, for decades, personal injury on the plaintiff side was the leader. Until, you can imagine, probably about 5 years ago, real estate took over. And I'm sure probably a lot of the trustees, if you get claims or potential claims, I would imagine they are probably related somehow to real estate. But as you can see, collection and bankruptcy, which is what most of you, I'm sure, fall in, is, I guess, fifth in line behind family, estate, personal injury plaintiff, and real estate. But I'll tell you, real estate is definitely, over the past few years, and I'm sure it's a product of the number of foreclosures, the number of real estate issues, we're seeing lots and lots of legal malpractice claims that have some sort of component of real estate in there. And here's the remainder. It goes down, like I said, these have 2% and less, so these are the really low risk. If you work in securities, or let's see, environmental law, you really have a very low chance of having a claim filed against you, according to the numbers. Recent trends. What they've done is, the last survey that was done was in 2008. This survey was actually completed in 2011, this most recent ABA survey. The interesting thing is collection and bankruptcy had the highest percentage of increase in claims. I would imagine that's probably a product of many more bankruptcies being filed. But, and you guys probably have a better idea of maybe why this is occurring, but...
It's because many more people that don't know what they're doing are filing.
Or maybe people who had areas, and this is one thing that we're seeing a lot of, is that, you know, with the downturn of the real estate, of the economy, downturn of real estate, a lot of people that had very heavy practices in real estate did not get a lot of work. And what we see a lot is practitioners who then transition into other areas, being litigation, maybe bankruptcy, other areas, and maybe that isn't their area of expertise, and they're dabbling in something which, understandably so, to make sure they can...
What do you got to do? Just fill out the form.
But obviously bills need to be paid, and staff needs to be paid, so we are seeing a good bit of that as well. But collection and bankruptcy has the highest percentage of increase in claims. Recent trends, areas of law with a large decrease in claims, personal injury plaintiffs are down almost 6%. That's a huge jump. So the reason for that, not totally sure, but again, it seems like the vast majority we're seeing these days have some component of real estate, which a lot of times involves a foreclosure or a bankruptcy as well. So, okay. What they also do is split it up by the type of work performed. And I know this is kind of hard to see, especially for those of you in the back, but the highest percentage, and this being the type, what was they're claiming that the lawyer did wrong? What did it relate around? The highest percentage is typically with preparation, filing, and transmittal of documents, having information that's incorrect. In the bankruptcy world, I'm sure that would be filing petitions and schedules that are incorrect. That could have been something that you guys missed on the lawyer side, but it also could be something that your staff person. If you allow your staff to do a large part of the filings and be heavily involved, you better make sure that you're double checking those, because as the lawyer, you're responsible for your paralegal or for your assistant. So you're responsible for that as the lawyer. So the vast majority is, again, preparation and filing of documents. Fairly close behind that is advice, just somebody giving legal advice that is incorrect. Now, we'll talk a little bit later about some defenses to some of the claims brought by advice, but this is just a breakdown. And certainly, with all of these things, we always have defenses to those allegations, but this is purely the type of claim, what it revolved around as far as the work performed. Any questions so far? Okay, and this is really hard to read. Oh, this is just the pie chart of those activities that we just talked about. Again, the most being the preparation, filing, and transmittal of documents. Claims by type of error. Interesting, I just talked about making sure that you are watching and looking over the shoulder of your paralegals and your staff. 30% of the claims, a little bit over 30 actually, are administrative errors. That being, it could be anything from a misfiling of a deadline, missing a deadline that couldn't be overcome. Again, administrative errors, 30%. Again, substantive errors being higher than that even, but again, just purely administrative errors. What they did is the survey broke each of these areas down. Administrative, again, being procrastination and performance and follow-up. Attorneys who you mean to follow up on something, you're required to follow up, and that follow-up never takes place. Losing documents. In this electronic age, I can tell you, you should be having some sort of electronic something in place where you can store documents electronically. If you're not doing so, scanning them in, however you keep it, that is a great backup to having a physical file. Failure to calendar, again, these are items, clerical errors, items that you will be responsible if your staff did not calendar something accordingly. Substantive errors, and this gets back to what we were just talking about. Failure to know and properly apply the law. If you're dabbling in an area of the law that you're not familiar with, that's where you really get into the most trouble. And I can tell you recently, I have a case right now that deals with a lawyer serving as a closing agent. Prior to the economy going south, they didn't do real estate. They were not a real estate lawyer. That wasn't their area of expertise. But they had sort of a channel where they could get some clients in for some real estate closings. And unfortunately, did not properly review the documents, and the people who, it was basically a title to a property, and the person who signed it was signing as POA. But what the lawyer didn't realize is that that property was held in trust, and the POA was not valid against that person in their capacity as trustee. And so even though they executed the documents, they went through with the sale, property was sold to a third party, the woman who was the trustee, who was advanced in age, is now saying, I didn't give authority, and you know what, that POA that I gave to my son, who my son has been apparently now trying to suck me for all my money, he didn't have authority to enter into that transaction. I didn't know about it, and you know what, we have a power of attorney that chances are it's not valid. And that is purely a product of the lawyer dabbling in an area that they're not necessarily familiar with. You can see the numbers. I won't go through all of them. Again, these are just substantive errors on the part of the lawyer or their staff, not just purely administrative errors. Final ones is client relations, failure to obtain consent and inform clients. I tell you, a lot of the cases that we get now, some of them that I've seen recently have some sort of component of a conflict of interest. Either a longtime client or a longtime friend, or they do work for, multiple people in the family, and maybe they never actually told one of the people that they needed to get independent advice of counsel, failed to advise them of a potential conflict, failed to ask them to seek independent advice of counsel. We see a lot of those kind of allegations of throwing in a conflict of interest. And then a very small percentage, 10%, are intentional wrongs. And hopefully nobody in here has any issues. Again, what you can see, these are solely based upon claims that are made, not necessarily any of them. They don't know whether any of these have merit, but I'll tell you, I have a case right now where the allegation against the lawyer is slander. So it happens. Just be careful with what you say and what you do. Okay, I'm going to go. Anyone have any questions? We're going to move out of the boring statistics side. Anyone have any questions so far on the statistics? Okay, just going to generally go through kind of Florida law on legal for legal malpractice. The jury instruction that will be given to jurors if you have a professional negligence case is basically the failure is to use reasonable care. Reasonable care on the part of a lawyer could be doing something that a careful lawyer would not do under like circumstances, or not doing something that a careful lawyer would do under like circumstances. The important key that we usually heavily rely upon is that phrase, under like circumstances, because as you all know, every case is different. Every client you have probably differs from another one that comes in the door. One of them wants you to do, and is willing to pay for you to do A through Z, right? But then you have clients that come in that don't really want to pay for A through Z. They want to pay for you to do, well, let's just do, A, B, and C. I can handle the rest myself, or I can do this, and I don't want to pay for you to do everything. So, again, the under like circumstances is huge in our world. That's usually what a lot of our defenses revolve around, is that every situation is different. And so we rely heavily on that language. The basic elements, the attorney's employment, and I'll go over that, break that down just a little bit. Breach of the duty, again, the duty to use reasonable care, and then that caused some sort of damage. I can tell you the causation, even though it looks pretty easy here in theory, there's a lot that has to be proven. Who can sue? And this goes to who you have a duty to. Under Florida law, the primary thing is only your clients can sue. Clients who you have privity with. Your direct client. If your client is John Smith can sue you. The important caveat to that is there has to be an attorney-client relationship with respect to the alleged malpractice. So just because you represent John Smith with regard to maybe a tax issue, if he decided to do something related to something else kind of on his own, you don't necessarily owe him a duty under that circumstance. But Florida law does have an exception to that. The primary time you see the exception is in the estates, wills, trust setting. And what Florida law says is that, let's just assume Luis is doing an estate plan. Estate plan names 3 beneficiaries. He owes a duty under Florida law to those beneficiaries that are named on the will. So it has to be an intended, and it has to be an apparent intended third-party beneficiary. And interestingly, what I'll tell you is there are actually cases where, and the big Florida Supreme Court case on this, is where supposedly a lawyer left out a beneficiary. There were 4 kids, only 3 were named on the will. They later sued the lawyer, the disgruntled beneficiary who wasn't named, tries to sue the lawyer, saying, you failed to include me. And the Florida Supreme Court said, no, they don't owe a duty to you. Lawyers only owe a duty to the clients who they have privity with and the intended and apparent beneficiary. So only the 3 beneficiaries named on that document can sue a lawyer. Most of the time, this comes up in the will and trust setting. I have a case now with a guardianship, and the court it's survived a motion to dismiss. The court saying, well, obviously the lawyer was representing, even though the lawyer was representing the guardian, the ward was the person who was being benefited. And the court said, actually Judge Kyle said it was sufficient that the lawyer I represent owed a duty to the ward. I know there's a case out there dealing with an adoption setting, and that the adopted child, the lawyer owed a duty to the adopted child, even though technically the lawyer was only representing the adoptive parents. So if there is a document that names somebody on them, there's a chance that person could sue you. Only if you do something wrong, of course. Okay, the statute of limitations, and this is unfortunately never as clean cut as we would like it to be. But for your client, who maybe you're doing a bankruptcy for somebody, you enter into a relationship, you do it, it is a 2-year statute of limitation from when that client knew or should have known of the negligence. I can tell you in the situation where there's beneficiaries, like we just talked about the trusts and wills, that statute 9511 only limits the 2 years to clients or to parties who are in privity with the lawyer. The argument being, and in fact I have not personally ever had this in front of a court before, I think the argument would be, well, those people are not in direct privity, and therefore they would be entitled to a 4-year statute. I think there is some authority out there for that. The difficulty usually comes in cases which there is a line of cases that say, even though 95.11 talks about a 2-year statute of limitations, the Florida Supreme Court has said, but you know what, that client did not sustain damages until the outcome of some other legal proceeding. And that's the Pete Marwick case that we talk here. It's actually an accounting malpractice case, but it's relied upon heavily in the legal malpractice realm, because what happened was they were claiming bad advice from a CPA with regard to some tax issues. They ended up getting audited by the IRS, and then they ended up appealing it to the tax court. Tax court ultimately found against the clients, and the Florida Supreme Court said that is when their claim accrued. So as soon as that decision from the tax court, or the tax appeals court came down, that was when they suffered damages, and therefore that's when they can sue you. And I can tell you this comes up a ton in our cases. A lot of times there's either an underlying lawsuit going on, like maybe you represent a client in a family law matter. They claim you did something wrong. They end up getting new counsel. And they're still working through that dissolution case, and they go ahead and sue you, even though that underlying case is still going. We almost always move to basically abate the legal malpractice case and say, look, it's not right. We don't even know if they've suffered any damages until the underlying case is done. And so that's where this whole accrual and this case law from the Florida Supreme Court has come down saying, despite the statute, they don't really sustain damages until the underlying or related lawsuit has been concluded. Interesting immunity. Lawyers, though, as lawyers, we are entitled to some forms of immunity. There's actually 2 primary ones that come up a decent bit. For trial lawyers, judgmental immunity is the best. The biggest thing is basically a tactical decision that a lawyer makes in good faith based upon a fairly debatable point of law is protected from liability under this doctrine. Basically what that says is that as a lawyer, we don't necessarily guarantee the outcome of what happens. We don't necessarily guarantee that every decision that we make is the right one. Again, the biggest issue for this is going to have to be that it was in good faith and that it was on a fairly debatable point of law. That was the initial case, but some of the cases coming after it, and I know it's hard for you guys to read in the back, but basically what the proto case said was that an attorney who acts in good faith and in honest belief that his advice and acts are well-founded and in the best interest of his client is not answerable for a mere error in judgment or for a mistake in a point of law, which has not been settled by the court of last resort in his state. So, a lot of times you might have situations, you have a point of law that maybe the Florida Supreme Court has never ruled on. Different DCAs have different opinions. If that's the case and you give your client some advice on how to do something, if that ends up later being wrong, or maybe the Supreme Court later comes out with a decision that undercuts it, you are entitled to judgmental immunity. As you can imagine, it sounds good on paper. Trying to get a judge to enter summary judgment for you on the point of judgmental immunity is not necessarily the easiest thing to get. But again, that's usually because the other side will have their expert say it wasn't, that point was solidified, it was not fairly debatable, and their decision couldn't have been made in good faith. So, again, it's good. We have, and there are cases upholding judgmental immunity, so it certainly is still out there. It's difficult to get summary judgment on. This next one is actually one of my favorites, and you would be surprised how many lawyers have not heard of it, or don't think that it applies to a lawyer, but it's actually the litigation immunity. All parties to a lawsuit, including lawyers, are absolutely immune from suit for basically any statements you make, any actions you take in that lawsuit. Somebody cannot file a standalone lawsuit against you for actions you took in another case. Now, your own client can, as a legal malpractice, but usually it's a case of an opposing party. I recently had a case in Collier County, and when I got the lawsuit, I was shocked, but the lawyer who was over on the East Coast, was suing my client. They were adversaries in an underlying lawsuit, opposing counsel. And it was actually a foreclosure case. And his entire lawsuit against my client, the lawyer, was, you raised a frivolous affirmative defense. And it took me 2 years to get a foreclosure, and had you not raised that frivolous affirmative defense, then I would have gotten summary judgment and my client wouldn't have had to pay X amount of dollars, and it'd take 2 years to have this foreclosure, basically get summary judgment on the foreclosure. And I can tell you there is cases right on point. The most recent one being a 2012 case out of the third that says, no, so long as the actions are related to a lawsuit, the lawyer is immune. The lawyers, all parties. It used to be a lot of lawyers thought that only statements that were made, you couldn't be sued for defamation. But it's any actions that are taken. And what this Lat AM case says, and that was a case against Holland and Knight, was, look, there's measures in place. In the underlying case, they could have filed a 57105. We all know what that is. They could have moved for sanctions in the underlying case and let the judge determine whether the affirmative defenses were frivolous. But we don't want a separate lawsuit. You don't have a right to bring a separate lawsuit based upon that. And actually, I had Judge, who was it? Hayes. Recently granted a motion to dismiss with prejudice at the first hearing on that lawsuit about the frivolous affirmative defenses related to the foreclosure. It's a really important case, and Judge Hayes, it was clear he did not want another lawsuit. That case actually had, there were multiple underlying lawsuits, and he said, no, the last thing that we need is lawsuits coming out of lawsuits about frivolous affirmative defenses. The courts are already burdened. We don't want any more lawsuits. You should have brought it up below, and you could have filed a 57105, and you didn't. You know, you're done. So this is one that you should, like I said, again, that was on a motion to dismiss, and he did not even grant them leave to amend, which I thought was important. As in every case, every tort case, you have to prove damages. I have to tell you, damages are particularly important and usually one of the biggest items of controversy in a legal malpractice case. The reason being is that, I'm sure most of you have heard, a legal malpractice case is basically a case within a case. You have a trial within a trial. You really have two different sets of jury instructions. And the most common that you think about is a blown statute of limitations. Let's just use a typical automobile accident case. You agree to represent a plaintiff who gets injured, gets rear-ended, has injuries. You blow the statute of limitations. Her damages, just because you blew the statute of limitations doesn't necessarily mean game over. Because what they have to prove, and what I call it is, we have to reverse engineer every legal malpractice case and say, okay, well, let's just assume we filed it. Let's assume that we filed this case. What would her damages have been? Maybe it was a really bad case anyways. Maybe you had really questionable causation. Maybe she was primarily at fault. Maybe the client was, under the influence of alcohol at the time. I mean, all the defenses, you basically try the automobile case and you try the legal malpractice case. With a blown statute of limitations, it's very difficult to defend the legal malpractice portion. So our efforts are focused on the underlying case. And again, the best way to do that is really to sit there and say, okay, let's just assume everything that client says we should have done, let's assume we did it. What position would they be in then? And the auto case is an easy one, but in cases where you have a very complex real estate deal, or you have a very complex business transaction, or even, the better yet, the conflict of interest scenario, you say, okay, well, let's just assume they got other counsel. We told them to get independent advice of counsel. They went out and got it. I mean, what would that counsel have told them? Not to do the deal? Or even if they had, wouldn't they have still probably gone through with the deal? Those are the type of issues that, again, is really important in the whole case within the case analysis for damages. Just some other defense considerations that we typically have is Payment of a judgment, just because you have a judgment, if the other side is not collectible, I mean, why should the lawyer be responsible for it? And again, actually, the most recent jury instructions, standard jury instructions that talk about professional liability, one of the components is that, let's just say, again, the auto accident case is that, okay, let's just assume that lawyer had filed within the statute of limitations. Was the other side collectible? Even if he had done so and she had pursued her auto case against the person who was at fault for the accident, could she have ever collected? At the end of the day, if they couldn't have collected in the case below, why should we be responsible? Because, lawyers we might have deeper pockets, or we might have insurance. They shouldn't be put in a better position just because they now have a case against their lawyer rather than the person who hit them in an auto accident. So a plaintiff actually has to prove collectability in the underlying case. A lot of times, again, it's kind of probably standard to a lot of civil tort cases, but speculative damages, we get those a lot, like had this lawyer done this, they would have, done all these things in the future. Well, again, some of those are really speculative. That usually comes up in the context of like a business deal. Damages not foreseeable. I'm sure some of you have dealt with just standard civil cases that deal with that. The final thing that actually comes up a lot, and it's a difficult one. A lot of times, and again, we'll use the auto case I just talked about because it's a simple example. Let's assume that the plaintiff in a case settles the underlying case with the tortfeasor. I don't know, maybe they didn't realize, or maybe it's not a strict, the tortfeasor didn't appreciate all of the statute of limitations necessarily argument, I guess. But a lot of times plaintiffs who sue lawyers will say, well, I had to accept significantly less in damages because you put me in a bad position, lawyer. And they settle in the underlying case. A lot of times lawyers say, well, hey, they settled, so they settled with the underlying party, so they've abandoned their claim. And so they shouldn't be able to bring a lawsuit against me because they settled the underlying case. And I would agree, a lot of times that's kind of your first reaction is, well, gosh, they settled it, so they were okay with that. But there's a line of cases, and one right out of the second DCA that says, no, because a lot of times what they do when they settle that is they're really just mitigating damages. They're getting something from the tortfeasor. But what then they have to prove is that they accepted less because of your negligence. So then their damages would be the difference between what they accepted that they claimed was mitigating their damages and what they feel the full value of their claim would be. So a lot of times when we get new cases in, we have clients that think, well, if they settled it, then they don't have a case against me. And unfortunately, that's not always the case. Most of the time, it's not the case, I should say. Okay, and this is really tiny, I know. And this is general. And I don't know if anyone here, the Florida Bar has some stuff online too about file retention. I'll go through this really quickly. Recently we haven't gotten a lot as far as file retention, but it's just basically litigation files should be kept typically for 6 years. Again, in the electronic age, you should be able to even keep them for longer periods than that if you wish. 6 years after the execution, let me see. Of a closing statement for if you're a plaintiff's PI case, 6 years for a statement of insurance client rights. Real estate, generally if you're not representing the seller or the buyer, is typically 10 years. Real estate loan files and real estate files where you're representing the seller or the buyer is 20 years. Real estate title opinions, 30 years. And then employment records for your own office. What was that?
I said, I'm not going to be around for 3 years.
And this is just time frames for keeping your own administrative type personnel items. But again, it's not. And we're getting close to the end, but I'm going to go through just a few do's and don'ts here. The biggest thing I can tell you, practical piece of advice, is spend time on your engagement agreement. Take the time. Don't use the same, a lot of the language can be boilerplate, but do not use the same engagement agreement for every single client that comes in the door. Obviously, you're going to have situations where some are the same, but spend time on it. I can tell you, time up front is well worth it. This is especially the case. Most people don't know that under the rules regulating the Florida Bar, if you intend to limit the scope of your representation, like I mentioned earlier, if you have a client that comes in that says, hey, I'm going to do X, Y, Z, I only want you to do this small piece. And normally you would do more than just that small piece, or the standard practitioner would do more than that. You have to get that in writing. There's actually a rule in the rules regulating the Florida Bar that says if you intend to limit your scope of representation, it has to be in writing. A lot of people don't realize that. Again, that's something that can be done at the outset of the litigation. As soon as you get your engagement agreement in place, just be specific. Take the time to be specific in that. I would say throughout, because as we all know, if it's not in writing, it wasn't said. I can't tell you how many times, and we're all guilty of it. We all are. If we could go back to anyone's file in here, my own included, and nitpick them, and that's what happens in legal malpractice cases. It's easy for lawyers to sit on the other side, in hindsight, not knowing the demands of the client at the time, not really knowing what's going on, and to nitpick your file in hindsight. You could nitpick any file in hindsight, but you have to get things in writing. I would say use a very good engagement letter. Spend the time then. Do never tell them you promise a specific outcome. We all know things are never guaranteed. I say some of the best engagement letters I see from my clients are ones that in their engagement letter say, you agree. I cannot, litigation is, who knows what'll happen, or I can't guarantee any outcomes, just put that in writing. Even get a little paragraph. I have some clients that I have, and I see their engagement letters, it has just like a heading of, that the results are not guaranteed, my results are not guaranteed, and then they have a little few sentences about the fact that no one knows what's going to happen and that you can't guarantee the success of the claim. Put that in writing. Your fees, put your fees in writing. Make it very clear as to how you're going to bill them, and then if you do that, make sure that that's what you do. So there's nothing worse than having something in writing and then your office was doing something different than what your engagement letter said. And it's happened, and we all, stuff like that, mistakes are made. Don't ignore your client. Return phone calls, return emails, and I can tell you, in the day and age of electronics, there is the phone is still one of the best ways to communicate with a client. And we all it's easy to shoot emails back really quickly on stuff, but if you think maybe there's an issue with a client, pick up the phone and call them. I can't tell you how much picking up the phone and calling them will help. And I can tell you, not returning phone calls is the #1 reason why people get bar grievances. Not a malpractice claim, but a bar grievance. And you know what the problem with that is that if it's enough, does anyone here know the process for bar grievances, like how the structure of the Florida Bar works? I'm happy to go over it, but I'll do a brief rundown. There's a Tallahassee, basically it's the ACAP hotline. They basically are kind of the first clearinghouse for the Florida Bar. Somebody sends a complaint about you, it goes there, they look at it, they determine the evidence, they basically ask the lawyer to submit a response, they analyze the response and the complaint, and they determine whether they believe there could be evidence to support, by clear and convincing evidence, a violation of one of the rules regulating the Florida Bar. I would tell you probably 90% of the complaints that come in there have some component of the lawyer will not return my phone calls, or I can never get in contact with them. And the problem with that is if it gets kicked out, because after the clearinghouse, it goes to Tampa Bar Council. Tampa Bar Council, even though they investigate it, they typically almost always refer it directly out to local committee. Local committee gets it, if they will typically ask to see your file. And so a lot of times when we represent clients in these matters, and sometimes they're related to a legal malpractice lawsuit, like the claimant decided to file a lawsuit and a bar grievance, sometimes just the grievance. What happens is we have a local committee member come and sit down and look at the file with them. And the bar is absolutely entitled to look at the file once it gets to that level. I can't tell you how many cases I've seen where we had an issue that was a minor one, fairly minor, come in, but then your file is open, and then they find a trust account issue. And I'm telling you, trust account they don't mess around with. So The one thing I can tell you is lack of communication with clients is the biggest complaint, and it can lead to so much more. So what seems like just a client who's pestering you, you know, and a lot of times it's inadvertent. And again, I talked about making sure that your fee agreement is in accord with what your practices were. I mean, I had one where literally it was a communication problem. It got kicked out to local committee. When they looked at his file, they're like, well, your fee agreement says that you were going to hold this money in trust, and you never sent her a billing, and you took all the money. And he believed that it was a flat fee, but his engagement letter said they were going to hold it in trust and just deduct fees off of it. That's a problem, because now the client is saying, well, I didn't agree to what he says. I agreed to what was in writing. So then we have a problem. So again, communication. Do not represent adverse interest unless it's clearly disclosed. If you think there's any chance of an adverse interest or any chance of a conflict, tell them about it. Tell them to get independent advice of counsel. Have them sign a conflict waiver. It's better to be above board than to have to worry about it later. Make sure you keep a calendar. I'm sure everyone here now keeps a calendar. Make sure, we all rely very heavily on our staff with our calendar. I mean, I'm sure we've all been caught in situations where something got miscalendared. Try to find a way, I guess, to try to keep on top of that. Obtain client's prior consent to associate with another attorney. If you're the second lawyer on a case, don't criticize the prior lawyer. When you have a client who comes in and they want that, honestly, it's a red flag right there, because chances are, the vast majority of the time, the problem is either a significant part the client's, or at least equally the fault of the prior lawyer and the client. So it's a little bit of a red flag. I would say never criticize the lawyer before you. Don't tell them you have malpractice insurance. If they ask, and most of you know the statute where you have to provide it if asked in writing, do that. But again, I wouldn't offer it up if someone says they have a problem. Don't say, I've got malpractice insurance. And you'd be surprised, people do. Don't defend your own malpractice claim. And this is not just my marketing ploy. This is, don't defend your own malpractice claim. It's extremely difficult for us to be unbiased when looking at our own work. We're all extremely defensive. Even if you get somebody that you trust, a lawyer, anybody, it's good to have somebody who hasn't been dealing with that client, doesn't know the issues, someone who's independent in judgment you can rely upon. So that's really important. Don't defend your own. Get malpractice insurance. Time records. And this is a really, really big one. And a lot of us, I know, we don't like to nickel and dime our clients. We have a lot of clients who won't deal with you nickel and diming your clients. But the one interesting thing about malpractice cases is that the billing records probably get used more than any other document in a file consistently. And that's because the lawyer will sit across from you at a deposition and say, isn't it true that this is typically hourly billing, that you bill by the hour and you only get paid if you bill? And you keep accurate time records, and if you did something on a file, you're going to bill for it. You're not going to just do it for free. And they do that. And unfortunately, your time records, maybe you didn't put it down. Even if you put it down and maybe do a no charge or something, I know some firms do that. Billing records are huge. They're huge. I have a very large malpractice case right now, and the problem is this one document that's in my client's 11 banker's boxes. I have literally 11 banker's boxes in my office of his file. There's one critical document in this case, which I'm really hoping the other side has not found yet. It's 1 out of 11 banker's boxes, and unfortunately, the first thing I did when I found it was go to his time entry to see, well, gosh, did he bill for looking at this file? Because if he had seen this document, he would have known this really big defense to this case. And I looked at his billing records, and he billed a significant amount of time for reviewing, a file like this thick. And it was in that file, and I'm like, gosh, if he had spent 2 hours reviewing that, there's no way he wouldn't have seen it. So it can work against you too, I guess. But billing records are key. Keep them. If you do if you want to just document what you did and do a no charge, absolutely. If you don't want to nickel and dime clients, but I would say the more detailed time records that you can keep showing what you're doing on file, most of the time plaintiffs, lawyers, and malpractice cases use those as a way of reconstructing what you did on a case. So try to do that. If there is a problem, advise the client before it gets worse. A lot of times you think, oh my gosh, I don't want the client to know, I messed this up. Most of the things in our world, a lot of things can be fixed. We all know, we make a mistake, usually, most of the time it can be fixed. Tell the client when it first happens. It's better than hiding it, and then it's snowballing into something significantly worse. And then the client feels like you were dishonest with them, which is a problem. Again, this goes back to writing. Confirm everything in writing. Even if it's an email, we use email so much these days, confirm everything in writing, especially if it's a major point. The final thing is, if you are outside of your field of practice, try to associate someone who is familiar with that area of the law. Even if you get your client's permission maybe to get someone in, if you're doing an estate matter, maybe even a contested estate matter, and there's a real estate issue, that you probably need the advice of a real estate lawyer just to get in on it, because maybe that's not necessarily your field. Get somebody involved. It's really important. The problems happen when you're practicing in an area that you're not familiar with. This is actually a portion of the rule, and I mentioned it earlier. It's just making sure that if you're limiting the scope of your representation, that you do so in writing. You have to get informed consent from the client. Okay, some potential danger signs, a bar grievance. We all know that. Typically, bar grievance or malpractice case, I would say if it's a big client, sometimes, and shockingly, I have a malpractice case right now where my client is still doing work for the person who has a malpractice case against them. It's not the norm. We've talked to my client. We've talked in detail with it many, many, many times. It's a very large client. They're happy with the general services. They're not happy with this one issue that happened. That is not the norm. If somebody files a bar complaint against you or files especially a legal malpractice case, withdraw. Withdraw. If you see, again, other lawyers getting involved, substitution of counsel, those are potential danger signs. If they ask you for a copy of their file, sometimes that can be a sign that something's going on. Bar grievance, any negative communications. Okay, and this is, I think we're nearing the end, but professional liability insurance. I think I saw some nods in the head that some nodding heads that not everyone in here has malpractice insurance. I can tell you it is dangerous to do that. It is dangerous to not, and I'm certainly not here on behalf of the insurance companies, but have malpractice insurance. It's really not that expensive. You can get it through, there's a couple companies here in Florida. You can get it through the Florida Bar. That's Florida Lawyers Mutual. They have fairly decent rates as long as you don't have a really bad claims history. Just for peace of mind, just for attorney's fees. I mean, the biggest benefit of an insurance policy is that you get a defense. We all know how much it costs to defend a big lawsuit. It's expensive. Your insurance policy provides a defense. That right there is worth a lot. One of the biggest things I'm seeing for those of you who do have insurance, you need to, number one, check your policy limit. Make sure that it's a decent policy limit. Be aware or be wary of what I call declining limits policies. There are a ton, and most of you probably don't even know. Most people that come in my door that have a declining limits policy never knew it. But you're usually offered a cheaper rate, and I think the Florida Lawyers Mutual through the Florida Bar, I think that the endorsement of a declining limits is actually their standard policy now. You have to actually ask that endorsement not be on there. But basically what that means, like let's say you have a $500,000 insurance policy. All of the defense costs, the cost to defend you, come off of that $500,000.
That's the standard.
And it is the standard. And so you have to actually ask that it not be a declining limits policy. And it's going to cost a little bit more. But I can tell you, in situations where you end up getting a large case against you, it's not uncommon for a big litigation, for a legal malpractice, when you have to start hiring experts. I mean, you have to have a standard of care expert, so I have to hire another lawyer to basically look at your file and say, everything he did was reasonable. Most of the time, we have to get some sort of expert CPA, forensic accountant, something, business valuation expert. I would say the average cost to defend most legal malpractice cases is probably in the 6 figures. Unfortunately, I have cases where I have right now a policy and a client whose policy is declining limits of $100,000. I don't know what to do with it. It puts us in a bad position too, because obviously we're worried about there not being any limits left. We need to hire an expert, but we don't really have the money to hire an expert, because the damages, if you look at the plaintiff's interrogatories, her damages are already in excess of supposedly of $100,000. So check the declining limits and make sure if it is declining, you probably should bump up your limit. You should probably consider bumping up your limits. That's the big one, is the declining limits. A lot of you probably don't know, and that most policies do also provide coverage for grievance matters, for a defense. A lot of times it's only like a set amount, like maybe your policy, they'll give you, $5,000 or $10,000 towards defending a grievance matter. But I can tell you, if you happen to get a grievance and you need to file a response, and especially if you're maybe a solo practitioner in a small firm, and you have like 1 million deadlines falling on you right about the time that this is coming in, and you're like, oh my gosh, how am I ever going to provide something decent? I don't even know how to respond. If you report that to your carrier, a lot of policies do have that endorsement that they will hire a lawyer to represent you in the grievance. And typically what happens is that we would get it. Again, when they come through my office or through insurance companies we work with, then we work with the client to basically provide a response on behalf of them to the Florida bar. If it gets kicked out to local grievance, then we deal with it then, and then again, you're not getting the day-to-day calls from the Florida bar. We are, and then we're corresponding with you. So check your policy about whether you have coverage for grievance matters. Do I get to choose the attorney? Most of the time, you do get to choose. A lot of times, they'll require you get to choose counsel. A lot of times, they will require that it be one of their panel counsel. There's usually they'll give you a few names of lawyers that can represent you, and you can choose between those. Typically, though, it's because they actually have contracts with different law firms, and so you usually have to go with one of their panel counsel. One thing, if you leave a firm and go to another firm, make sure that you have what they call tail coverage. A lot of times, what happens is the new firm that you go to is going to have coverage for you for anything that happens there. But if you individually get sued for work at your old firm, their policy might not necessarily cover you. So make sure it's called tail coverage. It covers basically all the prior stuff that if it comes up later, that's something that you should definitely talk to them about. Okay, and this is going to be, I think this is my final slide. And this is, sorry to bore, I would say within the past year, maybe 2 years, we are getting more and more cases coming in, not through insurance, not for malpractice, but issues between lawyers departing from a firm or firm dissolutions. And I can tell you, for those of you who do family, which I don't, but I do some legal malpractice related family cases, I understand family law cases are ugly. Lawyers departing are just as ugly. They're not always, but they can be just as ugly. It's what I call a professional divorce. And in this day and age, it seems like law firms and lawyers are fighting more and more over clients. And I know maybe part of it's a product of the economy. People are very territorial. A lot of times, again, lawyers leaving and thinking that somehow they own these clients and they own these files. If you are considering leaving a law firm, or if you're in a law firm now and you have somebody leaving, go look at the rule. I think the rule is very clear, but I can tell you, I have been involved in cases pre-suit, dealing with people leaving and sitting down and crafting an agreement as to who the joint letter will go to, specifically what clients, what it's going to say, making sure nobody talks to clients in the interim, all the way to lawsuits for, I mean, we've had multiple lawsuits that we have represented on both the lawyer leaving side as well as the law firm side of ugliness after somebody leaves, and injunctions, and so, you know, the lawyer is contacting clients, she's taken files, she's done all this when she left and trying to get an injunction to get those back. It's the biggest issue with the bar. You're not only looking at lawsuits, you're looking at serious issues with the bar. When 4-5.8 came into effect, and interestingly there's actually no case law on this rule, and that's because it came into effect several years ago, and it's the bar looks at it really from the perspective of the client. They want the client to be able to make the informed, independent choice to choose who they want to go with. Maybe, you know, they've been working with Diane directly for years and years and years, and even though they like Pavis, if she leaves, they want to work with Diane. They don't, but that's fine. The biggest issue is that when somebody leaves, there should be no contacting clients unilaterally from either side. The departing lawyer should not. The departing lawyer should not take any client files or client materials, no client lists, nothing like that. The firm should not contact clients unilaterally and say, hey, so-and-so's leaving, stay with us. You know, nobody should be doing that. The whole point is that the bar doesn't want clients in the middle of this battle. They don't want either side calling. And if you have these types of issues, it's not going to go well, because what happens is that then one side files a bar complaint, then the other side files a bar complaint, and then all of them are now facing issues with the bar. Clients are mad because now they're caught in the middle. It's just not a good situation. So if you're thinking of leaving, or if someone's leaving, I would absolutely direct you to Rule 4-5.8. Consider getting someone involved. If you think it's going to be a hostile situation, I recently got a call from a lawyer. She was meeting with the senior partners to go over the separation, and said, I'm worried that it's going to be a little tense. Would you come with me? And let's try to negotiate like a civilized, I guess, joint letter and who it's going to go to. Fine. And it worked out beautifully, because we just went in. You know, she felt intimidated and didn't want to be with them. So, you know, I did all the talking. We just basically went over, okay, here's how we're going to craft the joint letter. Here's what it's going to say. Most of that is really set forth by the Florida Bar. And then, okay, let's talk about what clients this is going to go to. And we just literally went through the clients it should go to. And both parties agree. No one's going to talk. No one's going to call these clients, either side. And just basically just a strategy. To sit down as professionals and do that. It really avoids a lot of problems later. So that would be my piece of advice, because again, it seems to be coming up a little bit more and more recently. And there is no such thing as a non-compete. I will tell you, if you're leaving, nobody can tell you that you're not allowed to compete. The Florida Bar prohibits any sort of non-compete with respect to lawyers. I know that was a lot to take in, and I probably talked really fast. But if anyone has any questions, feel free to ask me now, or if you want to come up later and ask me any questions, if you have any, or any thoughts about anything, I'm happy to speak with anybody. If you ever have a problem, feel free to call me or to email me. I'm happy to chat with you about it, but I appreciate you inviting me to come here.
We did put in for a CLE credit on this, but the Florida Bar has not gotten back with me on a course number. Once we have it, we'll get it out to everybody so you can get your credit for today. We'll probably post it on the web as well so you can find it there. Other than that, we'll probably have a meeting in December, maybe have some Christmas goodies or something to eat on. Brian has volunteered to do a little case law update for us to try to get some CLE credit at that meeting. It'll be a little more of a relaxed setting at the next one to kind of socialize and say hello to everybody. Judge, would you like to have the last word? Nothing today? Okay. Other than that, if anyone has any ideas for the January meeting or would like us to try to find a topic that you're interested in and someone to speak about it, then feel free to email me or Luis or Paul, and we'll try to get something arranged or a speaker on that topic. All right? Thank you.